Please, Your Lordship. Lordship, in this case, in post title phase, yes, case number has been typed.
Several occasions, my lord, we are trying to, my lord, find out the service report.
Actually, I
Did
will
you
be
also-
allowed to correct this.
You withdraw this and
My-
correct.
Today
The
also I
learned
come to
counsel
the,
for the petitioner is submits that there is a defect in the cost title of the bail application. Accordingly, he prays that he may be allowed to withdraw and file a fresh petition. Prayer stands allowed. That's why it is pending.
My-
We're
that's
trying all
pending.
throughout.
today morning also I called to OC.
Hmm.
He said that no, it is to 2024 not,
Hmm.
but it is 2020, my lord.
Hmm.
My lord, here also in the last occasion, Lordship was pleased to call for up-to-date CD, my lord.
Hmm.
CD was returned back, my lord, today not received, my lord.
Okay. When?
From South Salmara, my lord. 12, my lord.
Did
Sure,
not
sure.
this.
Yeah, please, Your Lordship. I'm for Mr. R. Rabha.
Hmm.
He is currently is unwell today, so.
Yes, when can he come?
My humble prayer is, in fact, the matter is already been heard by,
Heard,
and
heard.
I also give it in brief note.
You have given the
brief note of
Rabha was supposed to give a note.
the
Your notice there.
Yes, yes.
Yes.
On basis of that, Lordship can pass this order. I have no.
He is unwell today.
Everything is there. On
No problem is just suppose I allow your review. He is sick. Suppose,
yes,
assuming
yes,
for
yes,
a
yes,
moment.
in that,
Is not it? If suppose right now I pass a dictation dismissing your petition, then there may not be problem. But see, I'm expressing my view. I'm to a little extent. I think I need to apply my mind whether it's requires a review or not. No, that's correct. That's correct. Review is a very limited. If I have committed a mistake apparent, okay, of course, I will not hesitate. But if that mistake is not having anything to be
Yes, yes.
relatable to that, then I will not go to the merit. So therefore, because of these bans, I have not been able to apply mind to this.
Oh, yes, sir.
Okay.
Fixed
So
place.
when he can
Probably next week he is
What happened?
suffering
What?
from viral fever.
Viral
From
fever.
past
Okay,
3 days.
give it a next date. Then we'll on that day we'll close it and I will pass the judgment immediately before vacation. Okay. Because of these bans.
If you permit, I can already given the judgment. One judgment is.
That is there.
Yes, that is what STPL.
2024 sticks STPL. You have the copy?
Yes.
Please give that copy.
Already it is reported in SCC. Then it will
But
continue
this
for
I must say that this judgment has helped me in deciding some other cases. I should be thankful to you. In some other review cases, I have this help it. Yes.
And after that, another judgment also recently giving. Next date, I will give me on that review of that one.
Next week. It will not next time, much time. We may make it CAV and pass the deliver the judgment. 4th of December? 4th of December. On the prayer of Learned Counsel for the বস্তুখিনি আছে ন এইটো ডিক্টেশনৰ দিছিল এইটোত মই এভৰিথিং ইজ কমপ্লিট এইটো কোনে কৰিছিলে স্মিতা না Yes, reply file, Mr.
Appearing for the minister, they made a party. Because there's a main allegation.
They brought some by
So whether at this stage, your lordship will kindly, that's my respectful submission at this stage, whether your lordship will entertain this application. I have seen, my lord, the High Court rules. Whether this is, of course, your lordship, wide power.
No, that we understand. So that's why we have kept that open.
Yes.
We have kept that open whether at this stage during the conclusion of hearing, without the pleadings either in original pleading or in subsequent pleadings, that can be taken note of.
But
This is
I
one
just-
aspect.
Yes.
So therefore, since they have filed an affidavit, somebody said that we'll file only on this point a reply.
Mm.
You can raise that in that affidavit itself that this is not maintainable, it should not be looked into.
No, my
That
lord,
is,
this, of course, that can be also, there are some rule I have seen, High Court rules.
Mm.
Earlier, when a rule is being issued,
Mm.
what was the earlier?
Mm.
Once a rule issued, affidavit are exchanged, it has been heard. So in the meantime, whether something can be brought notice to the court, of course, with the permission of the court, certain new things,
yes, of course.
certain new things we have. So what my submission, it is not a new thing.
Mm.
They knew about it.
Mm.
My lord, what my respectful submission is, certain new.
No, so
discover-
therefore, we'll hear you. Just
Yeah.
before that, do you propose to say that you will not raise all these objections by way of an reply period, but you will verbally argue that?
My learned friend is saying that he wants to because.
That
he-
is the
No, no,
idea on
I-
last occasion.
No,
I have even expressed that you are, you will be liberty to raise all this, that this
No,
is
that-
not it to be thrown out.
But
Is
the-
that is, Mr.?
No,
I-
the
this one-
deponent was out of station, my lord, so.
Oh, that may be a different issue, but
Because I.
so if you say that no, will not file it, Mr. Das will argue on this. I will note down this argument. But
It will be better when it is on record.
that's why I've given you a chance on last occasion. Of course, we'll consider everything. Don't think that we'll not consider.
My lord, because I have to point out, I don't,
No,
I, for this, I will
In
not.
fact, Mr. Gogoi on last occasion said that these are the new facts, these are brought, we want to reply to it. So then I said, okay, we reply to it. It's not that filing will mean we have accepted
No,
everything.
that's
If
your lordship indicated.
indicated,
No, that time also is indicated.
indicated.
Your lordship indicated when your lordship has said, where is your pleading? Because what I remember, para 22 against me is in para 22.
Then only they said we'll bring out
We'll
on
bring out,
record.
because your
So whether that can be allowed or not allowed, if you say that that cannot be allowed, and if you say at the same time that I will verbally argue, no, orally argue, nothing is to be filed, then we'll
We'll
proceed
give
with.
one page argument. I will, one page, the reply.
That is what he says.
Yes,
They will
reply.
confine only to this, nothing more.
Only para 5 I will give a reply to.
That's all.
One page, para 5.
I think Mr. Gogoi, that was the understanding.
My lord,
Bonus.
the deponent was not available. I-
No, anyway, but Mr. Das said that he argued on merit too. That's why I thought
In-
that you are not filing and arguing on merit. Tell us what to do. Proceed.
You know, we'll.
No, I have no problem.
No. Any date, my lord, we'll give a time.
On last occasion also I told you, dear, that your arguments, their arguments, everything, facts, I have already dictated.
We will give a reply. We'll
That
give a-
dictation is over.
Yes, correct.
Now, this new facts has come, I will have to incorporate that part in the
Whether-
judgment, and thereafter I take my
No,
my
so-
decision.
So I will just.
So I'm waiting to
I'll give a
take a
reply.
final view after you conclude.
I'll give a reply to this particular. My learned friend said that he wants to file.
And you were supposed to give a
Bullet point.
bullet point.
So I just waiting because they said that they will give a reply to it. So
Huh,
that's why.
So let us propose it. Let us not delay this.
Clear.
By when you can file?
Next week you can do that. my lord.
Next week you file it. Huh? It would, in fact, the matter, one part is over. If I get time out of these criminal matters, then I will try to deliver the judgment before 21st. And if not, then on reopening out of these criminal matters, I will have time.
Almost your lordship has heard this matter.
No,
Yeah.
hearing is concluded. Hearing is concluded
No,
only
there
is, and
there are-
in fact, I have recorded what are your arguments.
There,
But to doubly assure
Yeah.
that I have properly recorded, I want your bullet point that I have not missed any
So-
argument,
so the-
any argument from you.
so
sir.
your lordship, what we understand, the lordship proposed,
Hmm.
this is that number one,
Hmm.
that they have filed, ultimately end of the hearing, this
Huh.
application
Hmm.
is not necessary that your lordship has allowed. Your lordship has said, okay, you file it.
You file it.
Subject to condition that they may file an objection. So that we are filing an objection,
Hmm.
your lordship will hear it. Now, first point is that whether this objection which they have filed is whether it is entertained.
There is now, there is nothing to
So-
be argued on merit.
so
Only
whether-
issue left is whether these pleadings, subsequent
So
pleadings and
whether-
your
So
objection.
we will make two arguments.
Hmm.
Even we'll say that it is not entertained at this stage.
Hmm.
Why it is not entertained? We'll
That is
say.
one aspect.
Number two,
And you also
number
argue,
two,
even if it is
even if
accepted, why it is
even
not
if it is
effective
accepted,
case. Why
even
not
the
effect your case?
evidence is accepted,
Hmm.
how it will change
Okay.
entire, how it will, that's what we will.
Yes,
be,
that's two part.
yes.
Lordship they can file a reply to by next week.
Ah.
And after 2-3 days, we give our bullet points and let it be.
All give bullet points, okay?
That
Please
would be.
don't try to file more.
No.
Bullet
Please
points,
don't
that's
try
what
to
Lordship
file more.
Not what
will
you
be
have argued
clear.
your summary bullet points, one
That's
page,
what
2 page.
Lordship wanted.
Not lengthy written
No,
argument,
just the
because
bullet points.
I have already recorded your argument. I can share it with you, but I'll not do that. Then I will verify whether I have missed some point
Right.
of your argument.
Hmm.
In your case also, say this our argument. If something I have missed, I'll incorporate in the judgment.
Right.
That's all.
In fact,
Need to
my lord, the reply now we will file, there will be a bullet point, only 2 points we have to clarify.
Okay,
As well
clarify.
as the maintainability of this particular,
Ah,
admissibility of.
That's
this.
all. And so far relating to merit, I have already recorded your argument, Mr. Das, Mr. KP Pathak, everybody's argument I have
Yes.
recorded. And if you want to add something, that these are our points which we have argued, not arguments, bullet points. That is what I have told.
Yes.
When list this matter for further hearing on
After we file for you.
13th of December.
13th of
13th of December. If the respondent number.
6.
Respondent number 6 prefers to file any objection to the last affidavit filed by the petitioner, raising objection including its maintainability, same may be filed prior to the aforesaid date.
I'm deeply honest. I'm deeply.
That's all.
Yeah.
This was your anxiety that I have accepted it.
No, your lordship,
So I have clarified.
I remember very well that his lordship is not accepted.
I said
Lordship
that
said
again.
you file it,
Uh.
they may file an objection, then we will decide.
Decide, yes.
Decide.
I propose him to file a fresh lordship, then our officer. will-
Okay.
Lordship.
Otherwise, lordship, there is a defect in the application itself. So I have asked him to file a fresh, our officer will
Lordship,
look
in
into it.
this regard, Lordship, everything Lordship is aware in my petitions I have.
No, please. If you want to argue on merit, argue. That's all. He has given a proposal that if he files, we will do his refresh. And if because see, other parts, otherwise you can close it on this basis. Why should you go and enter into? If you are insisting, it's up to you.
Lordship, I am saying, Lordship, everything before this honorable court and court,
No,
Lordship.
please answer. Are you arguing on merit?
Lordship.
Arguing on merit? Argue. Taking risks, dismiss, reject, everything is open. Yes.
Lordship, in this case, Lordship.
Ah.
My submission is that, Lordship, the petitioner number 1 is the father. And petitioner number 2 is the daughter. Petitioner number 1 is the absolute owner of a particular plot of land. He has applied for NOC as because he was desired to execute a deed, gift it to his daughter. So ultimately, Lordship, kindly peruse what are the documents is required for the NOC, which is mentions in their portal, Lordship.
You have
Kindly-
filed any affidavit subsequent to that?
Not, well, lordship.
That why there is delay and all, no explanation.
Not, only the thing is that lordship, his land was not as per DAG number, there is shorter.
No, that point, the flag we have raised.
That, to that effect, not filed, lordship.
Because if we enter into that, we'll go into that aspect. Because see, this court is more concerned
Lordship, I
with
understand.
the right of the citizen. And this act is enacted for the benefit of the citizens. And if we see that there is a rampant violation, even we may ask for departmental proceeding, whatnot. So therefore, we thought that at least you should make an explanation how and why the decision was taken at the last point, not within the prescribed period. Because we are sitting in this case as an kind of an appellate authority. We can consider everything. Therefore, we have called a record. Because at that point of appellate authority was not there. And this court already heard the matter at length. Therefore, in the fitness of thing, we would not like to send it to the appellate authority. So therefore, our power will be much more beyond the appellate authority, because at the same time, we are exercising a writ jurisdiction. So therefore, Mr. Roy,
Lordship, to that effect, Lordship, there are, by name, the person concerns are by name made party. They
Ah.
were not before your Lordship.
they are not before us. Notice were issued.
Yes, duly
They-
served. And Lordship, one thing, Lordship,
They have served also.
you already served. Duly
They
served.
were not there,
Lordship, one
Lordship.
thing, Lordship.
Okay, let them fix the music then.
Because let me file then let me file the affidavit,
That's what why I'm saying. See, that will help us determining also.
Lordship.
Because your case, we are taking it as a sample case.
Yes, Lordship. I am.
If we close it, they will definitely consider. And that proposal has come because this matter is pending.
Yes, Lord.
And they are also aware that something may go against them. Let me be frank, that's why they are giving you the proposal. We can close it with that proposal not going.
Lordship.
But this matter involves some public
Yes,
interest. An act has been enacted by the parliament, by the assembly in its wisdom state for the benefit of the citizen, and if some executive officer plays with the mandate of this, we will have to lay a guideline, we will take action.
Lordship, let me file the affidavit. then.
Okay.
Lordship.
If Lordship is deciding because he is not accepting the proposal,
Yes.
then let me. file
Lordship.
the-
I think so.
I mean, allow something. Lordship, I am saying, Lordship, whatever my friend is saying, their affidavit in this affidavit is reflected. Even moreover, Lordship, the
No,
private
no,
respondent.
what is reflected, he will say.
Lordship,
Are
that's
you
what-
objecting? He is filing an
Yes,
additional.
Lordship, that's why I'm saying, Lordship, once they have submitted, filed their affidavit, whatever their stand, as everything has been taken.
You are becoming more aggressive, which is
No,
not
Lordship.
necessary in this case.
No, Lordship. I-
You understand? I can right now close your petition and relegate you to the appellate authority right now. Heard Mr. So-and-so, learned counsel for the petitioner. This
I-
petition was filed against an order dated so-and-so. For the reason that at that point of time, there was no appellate authority. Since appellate authority has been constituted, this matter is relegated to the appellate authority. And if there is any delay, that is condoned by virtue of pending in this matter
Lordship,
in
I am
this court.
extremely sorry.
The
Lordship.
petition stands disposed of.
I am extremely sorry, Lordship. I am submitting in Lordship that thing that Lordship, private respondent, they have filed a focus reply, Lordship, details. So that's why I'm saying, whatever code is deemed and fit, Lordship, if the given times, Lordship, I am not objections, Lordship.
This is the order. Matter ends there.
No, Lordship, I am.
I made it part-heard only for the reason that there is an act to facilitate and to help public. The legislature in its wisdom has given specific time limit.
Yes.
They have prescribed for imposition of cost.
Yes.
And in this case, prima facie, these officers were not following the mandate.
Yes.
And they became wise when you came before this court. Let them explain.
Yes. Lordship.
Let them explain. And in our exercise of power, we may give further direction under 226. And you are only on your case. Your case is this, that order I have dictated. That is the can be the best fate of your case. You want that.
No,
So argue what is necessary. And don't be agitated when court is in your favor. Yes.
Highly obliged,
When?
Lordship.
2 weeks, Lordship.
2 weeks, January given it. As for further hearing.
Highly obliged.
Obliged.
Yes.
May I get some more time, 2-3 days? I could not collect the things, 2-3 days only.
2-3 days.
Yes, 2-3
Okay.
days.
Matter stands adjourned on the prayer of Mr. B. Sena, learned counsel for the petitioner. And be listed on. Keep a date in January, but no further adjournment.
Yes,
6th of January.
obliged.
Yes, anything? Tell us.
Chief, here this is, she has filed this for, actually it is shown as setting aside, but it's only for modification. because only fine was imposed under this section where he was pleaded guilty. That is why for modification, this petition has been filed, Lordship.
Mm.
As he had already admitted, so there is a provision of both.
Mm.
So maybe
Nothing. Provision of both. Provision of,
fine as well as imprisonment. is
now
there.
what is his imprisonment?
Imprisonment is fine of rupees 200 in default SI 200 for three sections. 200 is total 600 and in default 10 days simple imprisonment. That is what is awarded.
So then fine and imprisonment both are
So there,
both are there.
Both are
But
there.
if he pays, that is gone. He has pleaded guilty. What is that glaring illegality that will interfere under 482? Please assist her on this.
Lordship.
Nothing.
The material is also nothing, no more material. So all case see he or may Lordship may increase the fine also.
Let him pay the fine, Metaran there.
Under
He might have paid the fees in the fine in the meantime because none appears since long.
they may compromise
Is
also.
this AK Bora?
For 341 may extend to 1 month or with fine. For 323 it may extend to 1 year or fine of 1,000 or with both. And in 354 extend to 5 years and shall also be liable to fine. Shall not be less than 1 year.
And what has been given? Only fine.
Fine. With either description for which shall not be less than 1 year, but which may extend to 5 years and shall also be liable to fine. So under section 354, it's not or, it's and.
And so
And.
what is the punishment given?
Only fine.
Then that itself is a wrong thing.
Yes,
It is without jurisdiction. So instead of going to all this, let us close this petition. Otherwise, we have to issue notice. Is that it?
Or there is both. Others only fine.
Hard. None appeared for the petitioner when the matter was called for hearing on 5/11/2024. Full stop. This matter is pending since 2014. Full stop. Having no alternative, this court requested MSB Sharma Learned Counsel to assist accordingly. Having no alternative, this court engaged Mr. B. Sharma as amicus, appointed Mr. MSB Sharma as amicus in this case, and matter is fixed for hearing today. Full stop. The present application under section 482, read with section 397 and 401 of the Code of Criminal Procedure 1973, is filed for modification of the order dated 25/9/2013, passed in GR case number 97 of 2007 by the Learned Additional District Magistrate Dima Hasao Haflong. The prosecution case was launched on the basis of an FIR filed before Sarkari Bagan TOP, capital TOP, an police outpost under Haflong Police Station, inter alia alleging that on 19th of May 2007, the accused a leader of Congress within bracket I party at Lower Haflong assaulted the informant. It is the allegation in the affair that the informant was issued an appointment letter by Education Officer NC Hills Autonomous Council which the informant refused to accept as she had been working for last 5 years as LP school teacher. It is her further case that the education department has issued the new appointment letter on the advice of the accused. First of all, on the basis of the aforesaid FIR, Haflong PS case number 59/2007 under section 341, 323, 354 IPC was lodged. After completion of the investigation, search sheet was filed on 27/6/2007 before the district magistrate NC Hills under section 341/323/354 IPC against the accused Pradeep Saha, is not it? Liton, accused Liton Guha Roy. Subsequently, who is the accused here? Who is the Gita Kaur? Why Gita Kaur?
She is the victim.
Huh?
She is the victim. For modification, she had filed this.
For modification.
That is why they.
Okay. Mm. You see. But it's difficult if she has modification.
Okay. And 354 is there.
Yeah.
Yes.
Let us see the evidence. If we can see, we cannot shy away. If 354 convicted, how can admitted
Sir,
guilt?
See page 16. Here
Yes.
they specifically mentioned that
You see, say that
pleaded guilty. There is nothing that is some leniency, etc. Those things.
but
are-
guilty pleading conviction, there are some principles of law. How can it be simply somebody says guilty pleading will not mean that I have, in many cases, he will say that yes, I was there, I have done it. It will not mean that he has killed a person, there is a murder. So can a person be convicted by in that way? This is one aspect. Other aspect, if it is because he has not preferred appeal, if that be so, then can if it is convicted on pleading guilty, can a punishment be of sentence be given which is not prescribed under the law?
In
Who is for the respondent?
case of my lord.
So if it prescribes that minimum is
1 year. under 350.
maximum is 1 year and fine. So it cannot be the 0 and fine. Yes, Mr. What you say? All the criminal doings.
Bargaining when the occurrence took.
No, not plea of bargain, simply said guilty.
Conviction, plead on guilty.
Sonor case,
These are the cases of 2013,
offense of
2007.
2007.
So to plea of bargaining most probably introduced in 2007.
Hmm.
So plea of bargaining is altogether a different procedure being laid down. That is
Okay,
not-
so that procedure is not
Up to
followed.
7 years imprisonment, if the punishable, then it's plea of bargaining. Otherwise, so far with regard to if plea of bargaining is not there, my lord,
Hmm.
then the court has to consider and go for evidence, my lord.
Now, suppose somebody
Because
says,
plea of
I
bargaining-
plead guilty.
Yeah.
You are charged with, here is a case, charged with 341, 320, 354.
Yeah.
Now he says, I plead guilty.
Yeah.
Now what is the option left with the magistrate?
The learned magistrate will go for the trial, because here the plea of bargaining, if not all, before plea of bargaining, after plea of bargaining. Plea of bargaining concept was tried to be introduced in our legislature because, but it was not accepted on the plea that many persons like father is in a state of death, son committed an offense, and father takes the burden for this. He is a youngster. On that particular principle, it was not accepted. But it was in
Now
UK.
what here happened here is, it says the accused Gauhar Roy present, offense under so is explained to him, to which he pleaded guilty. His statement is recorded under section 313 CRPC.
Yeah.
On his own admission, he is found guilty of so. He is accordingly convicted and sentenced to pay rupees 200 on each count, amounting to rupees 600. In total,
600.
600.
In default, simple imprisonment.
Simple imprisonment of 10 days.
Yeah.
Now, under 354, only fine cannot be.
That cannot be. But,
But-
anyway, for these petty offenses as such, when where you find.
Can magistrate say that no, if it is petty offense, I can go beyond the prescription given in the
No,
statute?
it cannot. But the 360 will become probation of offenders.
There
has
is
been-
nothing, sir, nothing.
Nothing has been discussed, but that is mandatory again. 360, my lord, every case is, my lord, that this is not a fit case and reasons has to be recorded as per 361.
Uh-huh.
If it is
Why are you
reason is
giving
not-
that? The judgment we have already passed in some cases, that you will
Yes.
have to exercise this power.
Oh,
You
please.
give or not give is a different
Different.
issue, but this is a right of the accused
Yes.
to consider his case. And these are the parameters Supreme Court laid, and you have to apply mind to these parameters. It cannot be casual. I have considered rejected.
Yes.
That I think the day before yesterday, we have delivered a
Yes, that's
judgment.
the law.
Now, what will happen? Yes, Ms. Sharma, what do you suggest in these critical issues?
Lordship, here it's a very small one, try and say that, na? Possibly on that basis of this.
Where is the
only-
statement? Can you find out the statement recorded, 313?
I have a flag mark, Lordship. Pink color flag. But appeal cannot be done, Lordship, because if it is plead guilty and conviction given, no appeal lies, Lordship.
See, I'll read it. It is alleged that 313. It is alleged that on 19/5/2007 at about 7:30 p.m. at Lower Haflong near Soni Mandir, you wrongfully restrained Miss Swensu and assaulted her and also outraged her modesty. What have you got to say? Yes. Everything is included. Do you plead guilty? Second question.
yes.
Yes. Now, if that be so, if 354, what is the punishment prescribed?
No, 1 year, minimum is 1 year up to 5 years with. fine.
Minimum is 1 year, up to 5 years and fine. Now, therefore, the lady has come saying that this is wrong. I will have to answer it.
Cannot be less than 1 year.
And of- Other description for a term which shall not be less than 1 year, but which may extend to 5 years and shall also be liable to fine.
Anything.
So 323 and 341 is or. But
341 is fine. Fine has given because it is or either punishment or fine. But what about 354?
And this
And it is not that he simply pleaded guilty, specifically said to him that he have outraged the modesty.
minimum one is 1 year.
1
Yeah.
year.
Now, what is to be done? She has a case. He is not here. Notice served.
Yes, yes. And
Notice.
Advocate also appeared. See, the lawyer is not
not just in SK Medi chamber. Possibly his juniors, her name are also there.
Whose name?
J Das and A Das, their names are there. with
J
his
dash and A dash, okay. The present application is filed. This is where I feel bad. These are the young council, their names are there, they should take advantage of this. The present application is filed under Swenso. पिछला दिन ना लगे. Assailing an order dated 25/9/2013, whereby the learned magistrate found the respondent number 2 guilty of commission of offense under section 341, 323/344 IPC on for the reason that he had pleaded guilty. Full stop. Pleaded guilty. The present petition, the petitioner is aggrieved by such determination, and it is her case that even if guilty is pleaded, a person cannot be released only with payment of fine when it relates to section 3 for conviction under section 354 IPC, in as much as minimum prescription of sentence prescribed is 1 year. Full stop. This matter needs deliberation, and prima facie it is seen that the accused, respondent number 2, had unequivocally pleaded guilty of outraging modesty of the present petition. However, none appears for the respondent number 2 to defend. Accordingly, Mr. N. Deka, learned, yes, Mahajan, you come. Mahajan is here. Mr. Mahajan, N. Mahajan is requested to argue on behalf of the respondent number 2. Full stop. Registry to furnish the connected papers to Mr. Mahajan. Mahajan, list this matter again on. This will be an important case. What options should be left in absence of him? But apparently we'll see the evidence also. 161 statement, because there is no evidence. FIR, nothing is there. How a modesty is outraged. Only it's a appointment something, and it is not it. If 161 statement is also there, whether a person can be, suppose there is nothing as regards an offense of 354, can magistrate say that you have committed? These issues will come that you have committed 354 because on the basis of a police report. Is it not the application of it's I think required, I do not know. So then anything will be there. Somebody will say admitted. Where is that outraging of modesty? If no allegations under 161, which can consist, if we take it to be accepted, which may suggest that it is an offense under 354. Outraging of modesty. What is the outraging of modesty? That will come. So Mr. Mahajan, think over it. When? Tell us. 13th of December. Reflecting name of Mr. Mahajan in the corpus. Please find out whether case diary is here.
Case is not
Huh?
there, I think.
Yeah,
Case is
puts
not
up.
there.
The learned, the registry shall call the case diary of Haflong PS case number 59/07 under section 341, 323/354 IPC. Scan copies.
50.
59. 15.
আমার এখন নাই।
None appears for the petition. Sharma, bring the present status of this.
From here, I could see that last it was their case number, then 29 for evidence. That is what this our
There is
so we
no
can-
stay in this case.
next
I
case
think not.
date is 21/12/24 for evidence.
None appears for the petitioner on call. The present, this is from which portal?
This
E-
is
e-court name?
district court services ecourt.gov.in.
Okay, okay. Just give me the. That is, hey, Mosumi, mask to anybody other. Under section 482 of the Code of Criminal Procedure, praying for setting aside and quashing GR case number 593/2004 arising out of Silsar Police Station case number 348 of 2014
14.
under section 120B/406/428/471/409 IPC. You are from Sharma, you are from
Informant.
informant. Full stop. Full stop. Full stop. This court, while issuing notice of motion, did not pass any interim order staying further proceeding of the GR case number so and so, so and so. In view of the aforesaid, from the district website also heard, so none appears for petition paper, Mr. Sharma for state and MS B
MS.
Sharma for respondent number 2. From the website given, it is confirmed from the official website of district courts of Silchar, that is www.
E-court.
From the eCourts India portal, which reflects that. Tell us
It was last listed on 20.
that the case has proceeded and it was last listed on
9/10/24 for evidence.
29/10/2024 for evidence, and the
But
next
PW
date
was absent, so
and next
20
date
21/12/24.
and next date is fixed for 21/12/2024. In view of the aforesaid and stage of trial, this court is not inclined to interfere with the further proceeding of the aforesaid case. Accordingly, this criminal petition stands dismissed. 4641, same.
And return back the record is also there.
Any LCR?
Record is here, my lord.
How then that's okay. LCR be sent back. Records be sent back. But this was a case we could have. We will not do that.
My lord,
This is a more kind of a transaction, isn't it?
my lord, my lord.
The vehicles were defective or what? Vehicles were defective, okay, so. Or we pass it on merit. That there is specific allegation that defective vehicles were given, there is an initial deception, so dismissed. Yes, what is the next?
My lord, in item number 10, my lord, in the last occasion also they are absent, my lord.
This is item number
10, my lord.
10. This is
And Dolgao PS case number 61814 under section 376,
FIR crossing.
passing of FIR, my lord.
Any
FIR
interim
search-
order?
FIR search sheet, my lord.
Huh?
FIR and search sheet passing, my lord.
Search sheet crossing. Any interim order? No.
Perhaps not, my lord.
Yes, can you find it out from e-court portal? What happened? Unnecessary this
Right.
dust are creating.
They have also submitted one, my lord, compromise deed, my lord. On
Where?
the basis of they have came here for passing, my lord.
Compromise did.
My lord.
What was the issue?
376,
Oh, how can we?
my lord.
Where is the compromise deed?
My lord, I have flagged my lord in the record. The petition also there is, my lord.
Where is the FIR?
In the record, I have flagged my lord. In the record, LCR.
None appears for the petition or on file. The present application
In 164 also is categorically stated.
uh,
164.
this present application is filed under section 482 of the Code of Criminal Procedure 1974 for quashing of the proceeding of GR case number 3551 2014, including the FIR in Dolgaon PS case number 618 2014 under section 376, 313, 34 IPC and the search sheet filed in the aforesaid case. Full stop. The fundamental ground is that full stop. From the record, it is seen that the murder of the alleged rape victim lost and namely murder of the alleged rape victim lodged an FIR before the officer in charge Dolgaon police station that her daughter aged about 18 years, which is slightly mentally retarded, was working in the house of Alhaj Sanaullah of Gondapukhuri village. His driver Muhammad Abdul Haq had raped her several days forcefully in his house, and as a result of which the victim became pregnant for 2 months. Full stop. Full stop. The present petitioner Abdul Haq was the prime accused in the aforesaid case. Subsequently, police investigating officer filed search sheet. The statement of the victim was also recorded under section 164 CRPC. Recorded, which also shows that she stated before the learned magistrate that the accused Abdul Haq forcefully had sexual intercourse with her and also aborted her pregnancy forcefully. The present application is filed with the background that the mother of the victim, that is the informant, and the accused Abdul Haq entered into an agreement, and the mother has decided not to proceed in the case. Full stop. In the considered opinion of this court, though this court can allow compounding of offense in exercise of power under section 482 CRPC, however, this is not a fit case to exercise such power. Firstly, on the ground that this offense is heinous and serious in nature, and secondly, that a mother/informant cannot compromise with an accused on behalf of the victim, and it is the victim who has suffered. In view of the aforesaid, present criminal petition stands dismissed. LCRB returned. Yes, next. Yes, Mahajan.
This was that matter about whether assistant session judge, the appeal would lie to the.
That is clear, is not it?
Clear, I found some judgments were mostly against me, man.
What it says?
This 2000s criminal law judgment that this was appeal was admitted, my lord. Some person released on bail, my lord. It was pointed out that the judgment was from the assistant session judge. The matter was remanded back, my lord.
Now, according to you, what should be done in this case?
Chief on last occasion stated, asked my lord whether judge, additional session judge and the assistant center will be in the same division. Hereby, my lordship is I answered. One judgment is there that yes, same division, but the powers are different. And there's one Supreme Court judgment I found, my lord, 409, my lord. Because life imprisonment is there, my lord. It's triable by magistrate, my lord. The Supreme Court has said that no, it should be tried by Court of Sessions, my lord. In this case, 376, my lord, life imprisonment is there.
And it was tried by an assistant session judge.
It's the maximum. He does not have the discretion to do it, my lord. So in the Supreme Court case was since 409, my lord. The magistrate does not have the power to pass the sentence. It was said that the trial should be held by a Court of Sessions, my lord.
So in your case, it was a 376.
376.
The session delegated its power to assistant session judge.
That is not there in the record, my lord.
That is not there. How he could assume jurisdiction?
The section says by general or special order. There might be some order in that sessions
So,
division.
okay, let us assume for the time being that there was a general or special order. Let us assume. And it was given to an assistant session judge. Okay. Now, can it be given to an assistant session judge? What is losses?
I found our High Court division bench, my lord, says that
It can
yes,
be.
it can be,
Hmm.
but for sentencing, it will have to be sent to the sessions judge.
So for sentence, okay. So we go by the division jurisdictions.
That is at odds with the Supreme Court judgment.
That was?
It is at odds with the Supreme Court judgment, 2024 judgment, my lord.
Okay. So session judge, up to this, let us assume that there was a general or special order. Therefore, the session judge entrusted the trial to the assistant session judge. Now, after trial, what is the power of the assistant session judge?
Can try, but sentence can only be up to 10 years, my lord.
The sentence can already be up to the 10 years. Now, suppose he is convinced that it should be a life
He cannot-
maximum punishment,
he
then
cannot- as per our High Court, it will have to be sent back to the
send back to the session judge. So therefore, there must be a satisfaction in his order saying that this is a case maximum, I can give you only 10. Okay. Now, after that, it will go to appeal, will go to whom?
But in appeal also, my lord, section 194 CRPC says that additional sessions judge
Mm.
and assistant session judge can only,
Mm.
or the word only is used, my lord, take up appeals which have been sent by the, specifically sent by the sessions judge, my lord. My case, my lord, the appeal was heard by an additional session judge, my lord.
Mm.
So he is empowered by a general or special order, my lord, that is also not there, my lord. That is not there, then that appeal stage can be set aside, my lord. So you can take it up as an appeal, my lord, as last occasion pointed out, my lord.
Actually, what should be the exact situation? CRPC, please tell us.
The relevant sections are, my lord.
Let us read the sections. Now, it was taken on last occasion. I have everything is
The relevant sections are for, my lord, 6, 9, 10, 26, 28,
section.
6, 9,
Because I'm learning, that's why I am putting all this question.
and 6, my lord.
6 of CRPC.
Yeah.
Okay.
In 6, my lord, in the, my lord, lordship ansari judgment, my lord, it says that 6 classification of courts, my lord, courts of session. There is no court of assistant session judge, my lord, because judicial measure first class and second class has been clearly defined, my lord. So courts of session would include all 3, my lord.
Okay. If court of session includes all three,
All 3.
then a judgment passed by an assistant session judge, what will be the appellate authority by that logic?
But then, my lord, again, because, my lord,
This is one aspect.
yes, my lord.
Then
And then, my lord, 9, my lord.
9.
9(3).
9(3).
The High Court may also appoint additional session judge and assistant session judges to exercise jurisdiction in a court of session.
Okay, fine.
In Lordship Ansari judgment, my lord,
Mm.
he has said that they can exercise jurisdiction, but they can never be equated to the principal session judge, my lord, because he is the main session judge. He delegates his powers, my lord.
Okay, now section 3 said High Court may also appoint additional session judge and assistant session judge to exercise jurisdiction of a sessions court. Okay. Now, in this case, we presume that since they are appointed, it is the High Court who has appointed them. And therefore, they are equivalent with the session judge. We'll come to the answer judge. This is one aspect. Now, if they are equivalent, can an appeal be taken by a
That is why in the BNS, my lord, that provision, that post has been removed, my lord. Assistant. Congruous, my lord.
now? And what other section you want to say?
Section 10, my lord.
Section 10. What it says?
Subordination of assistant session judges.
Hmm.
All assistant session judges shall be subordinate to the sessions judge in whose court they exercise jurisdiction, my lord.
All assistant session judges shall be subordinate to session judge in whose court they exercise jurisdiction.
My lord.
Okay. So three things. If we go by read conjointly 8, 9, and 10. 8 says only there will be session judge. There is no concept of assistant additional. If we go by 9(3), though it is not recognized by the statute in section 6, however, High Court is empowered with a power to appoint additional and assistant. And therefore, in the event High Court exercises its power under section 9, subsection 3, then what will be their status is explained in section 10. So even if High Court appoints that appointment is to exercise the jurisdiction. Two part. One is to exercise the jurisdiction. Other part is their status. They will exercise the jurisdiction, but status will be below the session judge. Now, two issues. One is they are exercising a power of a session judge. Because a 376 can be tried by a session judge. So they are trying it by virtue of subsection 3 of section 9. They are given the jurisdiction. So when jurisdiction is given, they have exercised the power of a session judge. Do you propose to say by virtue of subsection 10, subsection 1 of section 10, an appeal will lie to the session judge?
The judgment same, my lord. Lord, in my lord, 193, my lord.
And what the appellate provision says?
That is also there, my lord. Section 193, my lord.
What says appellate provision?
193, my lord.
Hmm.
Cognizance of offences by courts of session, except as otherwise expressly provided by this court or by any other law for the time being in force, no court of session shall take cognizance of any offence as a court of original jurisdiction, unless the case has been committed to it by a magistrate under this code. The magistrate under 209 has to commit to the sessions
Okay.
court.
Here, magistrate has committed.
Magistrate has committed, my lord.
Because this is a offense triable by the sessions division.
Yes, my
Will not go as a judge. It's a triable by sessions.
In the my lord answer judgment, my lord, the magistrate committed it to a court of additional session judgment.
That is different issue. That cannot be. In that context, that judgment is there.
Then my
In
lord,
our context is this.
194, my lord.
Let us reframe it. Because I will forget. First is that conjoint reading of section 6, section 9, and section 10. What we get? Section 6 prescribes the constitution of court, according to which there is a court of session at the highest in district level. The subordinate judiciary, we will not say subordinate word is now being not appreciated. In district judiciary, sessions court. However, the legislature in its wisdom has empowered the High Court to appoint additional session judge and assistant session judge. The purpose is to exercise
His power.
jurisdiction of the session judge. Maybe for the reason that session judge is overburdened and whatnot. So to only to exercise power of the session judge, they are not session judges. Now, sub 10 says assistant session judge will be subordinate to the session judge. Now, there is a conflict of jurisdiction and status.
Then my lord, 194, my lord.
Now, 194. 194 says that these are the exclusively triable by the session. By virtue of appointment, an exclusively triable of session is being tried by an assistant judge. Okay?
General or special order, my lord.
Maybe for the time being, we are not going to that. We presume that since he has tried, there is a general or special order by virtue of appointment, because appointment itself says there's to exercise. Okay? Now he has exercised a power of session judge. Now, if he exercises a power of session judge, an appeal will lie to a court.
Same division.
Appeal will lie to a same division, to the session judge from assistant. From where do you get this?
194, my lord.
What says 194?
An additional session judge or assistant session judge shall try such cases as the session judge of the division may by general or special order make over to him for trial. Can try. Then, my lord, 381.
Let us see 381. 381.
With appellate power, my lord.
Tell us what 381 says.
Subject to the provision of subsection 2, an appeal to the Court of Session
Hmm.
or Sessions Judge shall be heard by a Sessions Judge or by an additional Sessions Judge.
Hmm.
Provided an appeal against a conviction or trial held by magistrate of the second class may be heard and disposed of by Assistant Sessions Judge or the Chief Judicial Magistrate.
Hmm.
2. An additional Sessions Judge, Assistant Sessions Judge or Chief Judicial Magistrate shall hear only such appeals as the Sessions Judge of the division may by general or special order make over to him,
Hmm.
or as the High Court may by special order direct him to hear.
So he hears it.
So again, he has to empower somebody to hear the appeal.
But where is that? Which you are?
381.
Huh?
381-2, my lord.
381-2. Yes. Appeal to the Court of Sessions, how hard? Hmm.
Yes, may I say something, ma'am?
Hmm?
Actually, my lord, there is a provision under section 374, ma'am.
374.
The 374, my lordship, may
Hmm.
kindly see, my lord.
Hmm.
It says any person convicted trial held by the High Court, extraordinary jurisdiction. 374 make it clear, my lord.
Yes, let us see.
Any
That is where they are also relying on that. My mind is not clear. That's why I'll ask you now a question. Yes, read this 374.
Your lordship don't mind, madam.
No, I welcome because for me it's a learning process. That's why I want to clarify
374
before
says,
going to the judgments.
any person convicted by trial held
Hmm.
by session judge
Hmm.
or additional session judge
Hmm.
or a trial held by any other court, means other than session addition.
Okay.
It includes assistant session judge.
Hmm.
It includes assistant judge in which sentence of imprisonment more than 7 years
Hmm.
has been passed against him or against any other convicted in the same trial.
May
appeal
appeal to High Court.
Yes, if it should be above 7 years.
Above 7 years.
If it's below 7 years, then your lordship can kindly see subsection 3.
Hmm.
If otherwise provided in subsection 2, any person convicted trial by magistrate, assistant session judge,
Hmm.
or magistrate first class. So assistant session judge comes, then it will be
Magistrate,
Mis-
first class or second class or sentence under section 305 or in respect of
so bar is the limit is 7 years. If it's below 7 years, he can appeal to session judge. Otherwise, to the High Court.
No, there is another aspect in my mind. See, assistant session, what is the jurisdiction of an assistant session judge?
The jurisdiction is 7 years, my lord.
No, from where do you get it?
That because they are that you'll also find it that
How do you say that it is 7 years?
28,
Huh?
28, section 28.
28, okay. Section 28. Let us understand nobody.
Subsection 3, lordship.
Huh?
Subsection 3, 20.
Uh,
28, subsection
An
3.
assistant session may pass any sentence authorized by law except sentence date of imprisonment, life or term not exceeding 10 years.
10 years.
Maximum is 10 years.
Yeah, 10 years.
Okay. So analogy is he can pass a sentence of maximum 10
10
years. And he has been entrusted to do a trial which conviction may be life.
But he cannot impose sentence above 10 years.
Cannot impose sentence. Okay. So if he cannot impose sentence, if it is less than 7 years, he can pass.
Yes, sir.
He's up to 10 years.
10.
So up to 10 years, he passes a sentence.
Yeah.
Suppose what is in your case 10 years?
7 years.
7 years. Forget about this. He passes an order of 10 years.
10 years.
Maximum.
Maximum.
Now appeal will lie
Like
to
the
whom?
High Court.
Appeal will to High Court. Now he passes an order of 7 years.
7 years.
It appeal will lie to
Session.
session judge. Now tell me one thing. What jurisdiction he was exercising? Forget about the sentence.
Original jurisdiction, trial.
Original jurisdiction of whom? Not his jurisdiction.
Just session judge.
A jurisdiction of a session judge.
Session judge.
Because it says that this can be tried exclusively by a session judge.
Session.
Please clear my mind.
Yeah,
huh?
yes.
It can be done by a session judge. However, High Court has been given a power to appoint additional and assistant
Assistant
session judge to exercise the jurisdiction,
No.
give emphasis on that, to exercise the jurisdiction of a session judge. Now, assistant session judge exercises a jurisdiction of a session judge. Sentence is, his power of granting sentence is less, is a different issue.
Yes, ma'am.
But if we come to the crux of the jurisdiction, he tried the offense as a session judge, so
As a citizen.
acquiring session judge jurisdiction.
Yes, sir.
When a person acts as a session judge, can only on the basis of prescription of sentence, the appeal will lie to the session judge? Because he is exercising his power as a session judge. This is my question.
I understand, ma'am.
Rest, fine,
I-
7 years, 6 years, something is different.
Yeah, yeah.
But he acquires the jurisdiction tried to an offense under 376 or 302 by virtue of statute or by virtue of power of giving power of High Court, whereby he is put to equal status of a session judge for purpose of exercising jurisdiction of session judge. This aspect can we ignore only on the basis of the sentence? This is my mind. I have
Yes,
seen
I-
all these judgment. It says he can exercise, but he cannot punishment.
Because-
Those are for the, can you say that this is relatable to the jurisdiction? Jurisdiction is one thing, and his exercise of jurisdiction is limited by some other. Can that be a
The
proposition?
competency also will come, my lord, because he's not competent to pass more than 10 years.
No, he cannot pass more than 10 years. We understand that.
Yes.
This is one. So he cannot pass is one thing, and his exercising jurisdiction is another thing. He exercises jurisdiction,
Means
passes an sentence which he can, but he exercises jurisdiction of a session
I
judge.
understand, but
Then can it lie to the?
because your lordship, there are cases of session tribal
Hmm.
where punishment is less than 10 years.
Huh.
So those cases are necessarily are sent to the
Therefore,
Yeah.
therefore, suppose he exercises a jurisdiction of a session judge,
yes, ma'am.
376, and you are preferring an appeal to the same authority whose authority was
Yeah.
given to him.
Caesar to Caesar.
Huh? Caesar to Caesar. Now, limitation is there to send
still,
pay
if-
sentence. That
But
is,
he's acting as an assistant session judge.
he's
that-
acting as a session judge.
But
So
whether
appeal will see he has exercised jurisdiction of
session judge for
yes.
limited period, but it is but is a assistant session judge. After all,
citizen. But for this case, he is a session judge.
yes, session judge.
Now, in terms of the statute, a judgment passed by the session judge will come to appeal to High Court. How he can take an appeal which he has delegated his power? This is my question.
Yeah, I understand. Because even then, my lord, even it is a
We understand.
yeah.
He has
nomenclature will remain
he
same.
has been given limited power of sentence. But if we go by
And moreover, your lordship, my kindly
go
say,
by subsection 3 of section
and
9,
officers were appointed assistant judges, they are grade 2 officers.
Huh?
That is also important.
that is important. But what it says?
They are not grade 1 officers.
No, that is a grade 1 officer, grade 2, that will come in a different way. Section 9, the primary statute,
Yes, ma'am.
which says the High Court may also appoint additional session judge and assistant session judge to exercise jurisdiction in a court of session. I am on the jurisdiction power and jurisdiction, not on sentence. I may give 7 years, I may not be a power to
No,
give
the
7
section-
years,
no,
but
your
I am
lordship,
exercising,
Subsection 5 is different thing, my lord.
yes.
When the office of the session judge is vacant,
Hmm.
when there is a vacant, then only question of make arrangements for disposal of urgent application which may not be pending before such court.
No, that is a different issue.
That
In
is-
certain circumstances,
The-
38 for 13 applications he is given to the, that is also in the judgment.
Huh?
Also in the unchanged husband, my lord. The court is vacant, my lord. Power is given to the assistant session or to take up application 438,
Hmm.
439 induction.
that is there, that is there. But you cannot ignore section 3.
application, no?
See, I may be wrong. This has come to my mind. What you say,
He is the High
everybody-
Court may also
this
appoint
the
assistant
debate is
session
open
judge
for everybody.
to
Mr.
exercise jurisdiction.
Bhuya, you are everybody is open here. Yes, Mr. Ahmed, just
Altogether,
Hmm.
magistrate power, district judge power, ministerial power, certain cases, first class magistrate tries it, wherein they can pass a sentence of 3 years,
Hmm.
and they are trying an offense which are punishable 7 years.
Hmm.
So, after going through, if wants to pass a sentence more than 3 years, then has to be sent to the session judge, to the CJM for passing the sentence. CJM has the power to pass a sentence of 7 years. And so, if a case has been tried by the CJM, wherein punishment is 10 years, jurisdiction to try is
Understand,
here.
understand,
So it
understand.
is sent to the
Now
CJM.
let us take this argument also. A session judge, by virtue of 9(3) or whatsoever, delegates an assistant session judge to exercise his power. This is the first thing.
Entrustment.
Entrustment. He entrusted his jurisdiction to an assistant session judge.
And the CJM entrusted in the.
No, now let us go to
under
this.
192.
Okay,
Yeah.
so he entrusts jurisdiction. So that person, assistant session judge, is having all power to try the suit. But by virtue of other provision, he do not have a power to sentence more than some years. Limitation is there. So therefore, though he can take it, do a trial, but he cannot sentence if he thinks that it is more than. This is one aspect. Agreed. This is a prescription of law. But if he thinks that I will pass more than 10 years, he will say that now this sentence since I am barred by law to pass, I give it to the sessions judge. Because the power is with the sessions division except sentencing, and he is exercising his power of trial. So far relating to sentence, it will be different. Fine. Now, if he thinks less than 7 years, he is only sentencing less. His jurisdiction is not an assistant session judge. His jurisdiction is a session judge himself. So how a appeal can be taken by the session judge? Sentence may be less. This is my question.
Yeah, ma'am. Yeah, ma'am.
Hmm.
26 million.
Hmm.
Courts by which offences are trial level.
Hmm.
Subject to the other provisions of this code.
Hmm.
The Honorable Supreme Court.
Section 26.
Of CRPC.
Yes.
Subject to the other provisions of this code, madam.
Ah.
It starts with that line, madam.
26, yes. Courts by which offense are triable.
A. A2, madam, the court of session, madam. Or as per the first schedule, madam. The first schedule says 376 per session, madam. Now, madam, 26 starts with subject to the other provisions of this code. Then, madam, will come to 28, madam.
No,
28
first case code. Subject to the other provision of this code, any offense under Indian Penal Code may be tried by the High Court, Sessions Court, so and so, so and so, so and so.
Go by the schedule, madam.
By the Kolba schedule.
No, no,
So
madam,
376 is schedule.
Then, madam, 28 says that he cannot pass more than 10 years.
Hmm.
Because other provision of this code, he cannot try that offense, madam, as per the Supreme Court, madam. Because if he cannot pass a sentence of more than 10 years, he cannot take up a case where life imprisonment is there, madam. That is what the Honorable Supreme Court says in this Amandeep Singh.
You want to say section 29.
29, 28, 28.
28.
28, madam.
A High Court may pass any sentence authorized by law. A session judge or additional session judge may pass any sentence authorized by law, but any sentence of death passed by any such judge shall be substituted. Any assistant session judge may pass sentence authorized by law, except a sentence of death or imprisonment of life or imprisonment of a term not exceeding 10 years.
So if he cannot pass more than 10 years, he cannot try 376. madam.
That is, no, even if we are not going to that extent, even if we accept that there is a power to delegate exercise power or entrustment of power, then he must have a power to pass the sentence because he is not acting as assistant session judge. He is exercising power of a session judge. Other he'll have to have a power to, because he is not acting as an assistant session judge. An assistant session judge is only not having power to sentence more than 10 years. But a judge exercising power of a sessions court, whatever you say is correct. If he cannot pass sentence, he cannot try also.
The CJM and the sessions, judge is the full sum, has all the powers. I mean, like Chief Justice, first in the roster system,
First of the master.
Master. So what I am on, that the legislator has categorized in that manner, that although it's a district judge, he is the boss, the CJM is the boss with regard to ministerial court. He has not been given the other powers, has not been given to the other magistrate. There are certain limitations.
No, I think you are not correct on that. So far relating to Chief Justice and High Court, there is no his status is equal. All are High Court judges.
Master of the roster.
He is first among the equals.
Equal, absolutely.
And he is the master of roster.
roster.
That will not mean that he can delegate a power, delegate his power to exercise somebody else except his in absence.
Absolutely.
Okay, number one. In these here also, what I am on is simple. As a layman, I am a layman so far relating to the criminal
No,
procedure.
actually, by virtue of statute, we have come, he has filed the appeal.
By virtue of
So
statute,
otherwise-
it's been categorized in that manner
So,
that a first
No,
class
therefore,
magistrate 3 years.
Therefore, by virtue of the statute
Yes.
prescription, certain offenses which
Categorized.
punishment is more than this
Yes,
is
categorized.
categorized, that is to be tried by a session judge.
Yes.
Okay. So no other can, this is a original jurisdiction. Suppose in Calcutta High Court, there is a original jurisdiction to try suit beyond certain limit. Okay. So in that way, that is where call it is a jurisdiction.
Yes.
To try an offense which is punishable more than so and so, so on and so forth,
Yes.
can only be tried by a session judge.
Yes.
Fine?
Yes.
No quarrel on that. Now, there is provision under this act which says High Court can appoint additional session judge and assistant session judge who can exercise the power of the session judge. Okay? So a power is given to exercise power of session judge, exclusive power of session judge to an additional session judge or an assistant session judge.
Session judge include additional session judge and
Understand? Understand? Now, if jurisdiction is given, then he will act as what? He
exercise-
cannot act as an assistant session judge because assistant session judge is not having any power to try a offense which is statutorily prescribed to be done by an session judge.
he is subordinate to session judge.
Yes,
He is subordinate to session
yes,
judge.
yes.
So if he is subordinate to session judge, how can he try a offense which is tribal session judge?
Because
By virtue of the power given under
Yes.
the statute. So if statute gives his power, he is no more remains subordinate when he exercises. He assumes the jurisdiction of a session judge for the purpose of the said case.
Absolutely.
Is not it?
Yes.
if
Only
that-
for the point of sentence.
Absolutely.
That is not been given.
No. Let us understand. If that being given, so he exercises a power of session judge.
Yeah.
A session judge can suppose that is not tried by a session judge, but by an assistant session judge, by a session judge. And punishment is given 10 years. Appeal will lie to whom? High Court. So he exercises a jurisdiction of a session judge. He cannot impose punishment by virtue of limitation under the statute of an assistant session judge. Subject to correction, my view is that limitation will also not be there when he exercises power as a session judge. That is debatable.
Because the also is very clear, section 10 says is
Ah.
all assistant session judges
Ah.
shall be subordinate to session judge, in whose court they exercise jurisdiction.
But
Even-
here he is not acting as a session judge. He is not acting as a subordinate. Moment you say a subordinate judge is acting, then whole case goes because it is only triable by a session judge, not by an assistant session judge. He is not subordinate when he tries a sessions tribal offense.
And the High Court has given the power.
When High Court has given the power. Now, therefore, how his judgment, maybe 7 years, 6 years, 5 years, less than 10 years, will go to his appeal to a session judge when he is not acting as a subordinate, but exercising the jurisdiction of session judge. This is my question. Think over it. Because I have seen those judgments. Everything is that since he is subordinate, he has passed it, so he is subordinate, it will come to the session judge. He is not subordinate while trying this offense. For other offenses, he may be subordinate, which will come to, which is not sessions tribal, or which is less something different. Then this is my view. Please convince me.
It's a session division.
Huh?
Court of session will include session judge additional and assistant, my lord.
Understand? So
But-
therefore,
Assistant
Eh,
judge
mhm.
is different from the other two, my lord.
Ah,
He is
under-
superior. In a
understand.
way, he is superior.
he's superior.
That is why
But the statute gives power to whom to try 376?
no session, my lord, not sessions judge.
Court of session.
No session will include all.
So if it is court of session, appeal will lie to whom? Whatsoever, irrespective of punishment.
Appeal for, we have to go 381, my lord, how to be heard. Session judge will appoint, delegate to additional or assistant, my lord,
Mhm.
to take up the appeal. my lord.
Delegate
to be
means, delegates what? Delegates what?
It's his own power.
His own power. So if his own power is delegated, how can again he take the appeal? Maybe 7 years, maybe 10 years. This is my idea.
Yes, my lord.
Please say that this is
Because of
not
the
correct.
statute, my lord.
Huh?
Otherwise, because of the statutory provision under section 372, my lord.
No,
So it's a-
not because of the statute. According to me, statute is clear. Interpretation is wrong.
374, my lord.
Yes. Statute says that statute says his power, assistant session judge's power, what he can do, what he cannot do. But when you delegate to exercising power as sessions court, he is not exercising his power under as a assistant session judge. If he is not acting, according to me, even he will have a power to make punishment.
Then, my lord, if
But
lord,
that's why limited by whether.
If it is limited, okay, if it is limited, if we accept that, then also session judge may exercise the power to give higher because that power is not there. And jurisdiction is conferred by delegation. By statute, there is a bar. So he can exercise that is fine. But if he passes a sentence within his jurisdiction, sentence part is fine. But so far relating to the original jurisdiction, he is acting as a session judge. So therefore, how maybe 7 years, maybe 10 years, how it will lie to the session judge? He is not exercising as a subordinate in this case. This is,
my lord, that.
then what
it-
will happen to your case? Your appeal will go. And we'll have to take the appeal as a first appeal.
first
Then you have a right of argument on all the things, because otherwise you are is a revisional court where our power is will not go each and every evidence. But before that, satisfy on this.
My sentence, my
My
lord.
lord, my argument for this case, my lord, then the trial will also go, my lord. Because he cannot pass that sentence subject to other provision of that court, my lord. He cannot take that case also, my lord.
If I pass the judgment, then my court will be cleared. That
My lord, because that.
Punishment
that
has
is
been enhanced. Now,
no,
sitting judge.
now is something different.
Now there is no.
What he's saying is that what I am saying, that if he is a power to try, he will have a power to sentence.
Yes.
Not as an assistant session judge, by virtue of his delegation of power.
But there is a limitation.
No, then there will be no limitation also. That is, I am not going to that way.
But that will go against the statute, CRBC. my lord.
No, that will not go against CRBC. What is the limitation is given to an assistant session judge?
Yes. Because case, your also may kindly see,
Mm.
case doesn't go to the assistant session judge unless session judge.
That's it. That's session judge can entrust what? By virtue of this act.
Only session cases, man.
His power.
Yes, to try is a big way. Their sentence is,
Only his power to try.
he must see.
So, is there a distinction that I am giving my power to try to you, but you cannot give a sentence?
Yes, naturally they wish to see. Because
Limited by the statute.
That has been limited by sessions to an assistant session judge, not to a judge who is exercising power of a session judge. This is my concept. He cannot pass an sentence more than 10 years.
Your lordship's,
By there is a limitation, by the statutory limitation.
your lordship's argument is that when he is entering the shoes of a session judge,
Session judge.
then he will be a session judge for all purposes.
Session judge.
For all purposes.
For the purposes. His assistant says that his subordinate, it will not come. If he's subordinate, how can he try a sessions court?
Actually, it's a limited part it was delegated.
Huh?
If we are
Can
only section
there
level-
be delegation of, that's why I'm saying, I was asking you to find out those judgments on jurisdiction.
Jurisdiction point.
All these sections have been removed in the BNSS, my lord.
Forget about BNSS, we are in CRPC.
So,
We are on CRPC. And to exercise all those, it will take another 5 years by us. We are still on CRPC.
Those cases can, Lordship,
Exactly.
judgment which I have given to.
But this is one.
This is distinguished by our High Court by saying that assistant session judge can make over, return the file to the session judge if
For
they are
sentencing.
for sentencing. But that regarding that, Lordship, I have some reservations because, Lordship, section 325 of CRPC says that magistrate can delegate to CGM for passing order on sentence if it is more beyond his jurisdiction. But that power is not given to the judges. It is only in respect of the magistrate. So in my humble understanding, Lordship, that section 28 is probably like our High Court's rule that is, if it is below 10 years, that will be tried by single judge. And if it is above 10, then will be division bench. Because it is like, section 20 is like that. Lordship. Then
No.
if it is below 10 years, then assistant session judge can try. And if it is above 10 years, then it will go to additional or something.
That's like that only.
Maximum punishment we have to, your lordship, that have,
For maximum
No,
punishment.
I have reservation on that.
because.
I will go, I may go by all these judgment.
Because your lordship, there are many session travel cases where maximum punishment is 10 years or below 10 years. So those cases were sent to the,
Because this is there is a synchronization of power to exercise and to sentence. Two part.
Yes.
But if you delegate a power of a session judge, knowing fully well that it can be a 302, life sentence can be there, he's exercising a jurisdiction of your jurisdiction, but by virtue of limitation, he cannot pass a sentence. What is this? This will be a paradoxical situation.
It's not, doesn't match up.
Ah.
That is why this
So
409
according to you, your whole thing will go.
because 409, Supreme Court has said cannot be taken up by magistrate, has to be taken up by session judge because life is there. Court judgment, which is this. But then, my lord, this.
The High Court.
High Court relied on the provision that assistant session judge.
Can you show me that what our High Court division bench decided is in derogation of Supreme Court judgment? Forget about
It's
Bombay.
2016, my lord, I placed my lord.
Ah.
There, my lord. Para 17, the last para only.
Paragraph, which judgment?
2016, SCC online, GAU 409.
2016.
First, my lord, para 9, my lord. Fifth line, my lord, does.
Does.
Court of session would ordinarily mean not only court of session, but also the court of additional session judge and assistant session judge. And once an additional session judge or assistant session judge is appointed by the High Court to exercise jurisdiction in a court of session, they become part of a sessions division and can try cases trialable by the court of session. Then, my lord, para 17.
Para 17.
17.
This is fine.
On a case being made over for trial by a sessions judge in exercise of power under section 194 of the code to a assistant session judge, the assistant sessions judge is competent to try the same irrespective of the fact whether the assistant session judge is competent to impose the minimum sentence authorized by law or not. The assistant session judge can also deliver judgment in such cases, and in the event of conviction, if it is unable to impose the minimum sentence, the case record is to be placed before the session judge to conduct hearing on sentence and pass appropriate sentence in accordance with law. That second part, my lord, that is not a creation of statute, that is a creation of our High Court, my lord.
Any other judgment, Supreme Court and all?
Supreme Court, this one, my lord, this 2024, my lord.
Huh?
2024, my lord.
24.
Yes, my lord. The bail application, my lord. Then it went into the other aspects, my lord. That's 26, my lord.
Ah. 20.
6, my lord. Ninth line, my lord, Pithili. Pithili
Italy.
stated, the sole solution to avert a situation to raise the contention of conduct of a trial before a court lacking jurisdictional competence in any given situation is conduct of a trial for an offense under section 409 before a court of session. Since no minimum sentence is prescribed, no prejudice would be caused to the accused concerned, or to the prosecution by the conduct of a trial before a court of session, as it be open to the sessions court to impose lesser or higher sentence than 7 years of either description in case of conviction taking into account all relevant aspects.
Hmm.
So came to this conclusion because my lord 26 starts with that subject to the other provisions of this code.
Sir, please tell us which are the sections we have just gone through. I'll just note it down.
The second 6, my lord,
Section
6,
6,
9,
Section 9,
10,
Section 10,
26,
26,
28,
28,
194,
194,
374,
374,
and 381, my lord.
381. Ah. All you are outside? You people are outside?
Outside.
Hard in part.
That one section. of
Yes.
Five.
Section 235.
Sentence part only will come only after hearing the accused on the point of sentence.
Hmm.
So if the assistant session judge heard this, the accused on this point, and thereafter again he have to send back to the learned session judge from the stage of argument. Because he cannot pass the sentence without going through the records or without hearing the parties lord. Because he have to see the entire material on record, then proper sentence he has to. And the assistant session judge cannot compel him to pass an exact sentence. lord.
So what you propose to say is that first aspect, if a session judge delegates his power to try an offense which is exclusively tried by sessions, either the assistant session judge will have all power to act as a session judge. Number one. Alternatively, in view of limitation of an assistant judge to pass and sentence not more than 10 years, he will have no jurisdiction to try an offense when the prescription is more than 10 years. This is your argument. And therefore, the trial itself will be vitiated.
And 28, very clear in the judgment.
26 and 28.
One aspect is there. The honorable he already placed before
Yes,
lordship.
that is
That says lordship that this question cannot be raised at the stage of appeal. That
yes, failure of
we are,
justice has to
we
be
are, we
shown.
are in revision, so
Yes.
Of justice has to be shown that it was prejudice to the accused. That has to be shown.
Your ground is that we have faced the trial. And that's why I'm asking you the jurisdiction. In case of jurisdiction, that can be raised at any stage. Not for pecuniary jurisdiction, that the subject matter jurisdiction.
Yes, Mr. Chairman, this is there, madam.
probably my case lordship maximum
Hmm.
section, then probably he cannot.
But in your
Yes,
case,
life.
that is
Life is there.
life is there.
Minimum 7, maximum life. madam. That lordship has said, madam,
Abhisati Sesa. Ina kiman number aছিলে? Develop কলে হল কাবি শাস্তি Sesar judgment to print out DSL. I'll give you some judgments.
that lordship has
See,
said, madam,
fundamental issue is what is jurisdiction?
that para 28, madam. Accused can claim to be tried by a court having competent jurisdiction to try, madam.
Paragraph
28, madam. That's
Of?
Supreme Court. Supreme Court, madam.
this is 2023.
24, madam.
24.
24. Madam.
28, na?
Yes, madam. Certainly, standing the trial is said to be an ordeal. Hence, in the light of provision of section 301 of CRPC, we have no hesitation to hold that an accused is having a right to claim to be tried if he were to be tried before a court of competent jurisdiction because acquittal or conviction by a court lacking competence would not be a bar for a second trial. This is where the point of jurisdiction can be raised at any point, my lord.
That can help you. So your whole case is that, yes, there is a power of delegation, but that power of delegation is limited by the power to sentence. This is your case. So when he cannot pass a sentence, he cannot be delegated and entrusted a jurisdiction where he cannot pass a sentence. So his jurisdiction should be limited
10 years.
to that sentence. So there is a judgment, Hassan Abbas Sayed versus Usman Abbas Sayed. I think. No, or you can take Harsan Simanlal Modi versus DLF University, where it was held that this was basically to the arbitration proceeding, jurisdiction of a civil court and arbitration. Then all these questions were raised, when to be raised, when not to be raised. It was held that so far relating to pecuniary jurisdiction and territorial jurisdiction, this will not create any defect. It will have to take at the earliest. So far relating to subject matter jurisdiction at any stage. And your whole case is this a subject matter. Until and unless offense prescribe, he cannot pass, he cannot assume jurisdiction by virtue of any delegation. So it must be a jurisdiction complete, either whole or not at all.
Yes.
Important point. So it says the law is well settled at point that if such where a court has no jurisdiction of subject matter of the suit by reason of any limitation imposed by statute, charter or commission, it cannot take up the cause or matter. An order passed by the court has no jurisdiction is a nullity. So your whole case is that by virtue of limitation, it cannot take. Take note of this judgment.
Harsan Simanlal Modi, my lord.
Harshad Simanlal Modi versus DLF Universal Limited 2005 7 SCC 791. AR Antule is the best judgment that even no court can confer jurisdiction when it is none. Supreme Court conferred jurisdiction upon the special judge to try, upon a judge to try a matter. Statute says it can be tried only by special judge. Supreme Court subsequently says, yes, we are wrong. We cannot confer jurisdiction upon an authority which is not having. Your whole case is that assistant session judge will have a jurisdiction till he has a power to pass sentence. Here are some judgments I relied on earlier, past a judgment. Arun Kumar versus Union of India. 2007, 1 SCC 3732. So what is a jurisdictional fact that is been dealt? Hard in part. List it for further hearing when? For you people, it's easy. For me, it's very difficult. There are
Such is convenient.
think
More money is larger. Segment.
you cannot think at this level to get a relief on this point. You'll have to think above the threshold. More particularly, what is jurisdiction, how it is conferred, and how it is to be exercised. And if in a defect of jurisdiction, what will be the result? Eighteenth of December, food for thought for vacation. And both of criminal don't think over it. We may ask
Fine,
you.
fine. That would be the correct proposition.
Huh?
While session judge exercising his jurisdiction under the chapter itself would have to see the offense that has been alleged of and thereafter entrust it, not that.
You cannot have a part
Absolutely.
jurisdiction.
That
And
would
this
be the
is-
correct view, and that would amount to, my lord, reasonableness with regard to
So
High Court.
why
giving
an
the power-
accused should be sent to a court
Yes.
who is
it-
not competent to
Pass a sentence.
pass a sentence? It
Yes.
is it is prejudice.
Prison. That will be a harmonious construction with regard to interpretation with all the provisions.
Okay, what is this item number?
Well,
Well, the judgment, my lord, a revision against the judgment of conviction. under the
Conviction?
NI Act, The section 138.
What are the grounds?
Now, basically, my lord, what has happened as per the complaint, my lord.
This is first, the second time. First, if there is an appeal,
Appeal,
okay,
appeal.
okay.
Yes, the complaint statement, my lord.
Hmm.
That on 8/2/2024, my lord.
Hmm.
That I took a loan of rupees 2,70,000. And over a period of 5 months. And on that day itself,
Hmm.
3 checks were issued amounting to 1 lakh each and 70,000 another, my lord, on same day. And that is the complaint that has been filed, and accordingly evidence also adduced. But in
Which
procedure,
paragraph in the complaint, page and
page
paragraph?
14, my lord.
Page 14 of the revision petition,
Paragraph 3, my lord.
paragraph 3.
Now, what has happened in the cross-examination of the complainant, my lord? Cross-examination of the complaint, my lord, he has stated, my lord, your lordship may kindly come to cross-examination, but I have discussion person, my lord. That is page 20, my lord.
Hmm.
There he says, my lord, that as the accused is I know the accused for last 10 years, he is my friend. My occupation is of business, accused is also my friend. So I given him the money, I did not go to business for giving loan. The 3 checks to amount of 1 lakh each and another amount 70 were given by the accused as a security for the loan. Checks were given only as security, not against liability. That line.
Okay,
Now,
so, okay.
now 3 checks were contained same date. I have not seen a document where the accused capacity return, it is not fair. So
This is the statement of the
complainant.
complainant in cross-examination.
So there was no re-examination by the complainant
Okay,
to clarify whether it was for security or not. That is another, there's one aspect. Though in my defense, I have given defense evidence that I paid the loan. But there was no receipt. That is another issue. Now the point is that if it is a use as security, whether an act is
Applicable.
accepted or not.
what is the law says?
Law, my lord, your lordship will file.
So this is the only ground.
This is the only. Because your earlier, my lord, that is Sudhir Kumar Bhalla, my lord. That is 2008.
But I'll tell you, when you argue, just presume that I know nothing.
No,
So
no,
don't go by in a way that this law is settled. So
Sudhir Goyal Kumar Bhalla, my lord.
Hmm.
Paragraph 22, my lord.
citation
Citation, I'm giving the citation, 2008 7 SSC, page 137.
2008 7 SCC
SSC, page 137, my lord.
page 137.
That it has been stated, my lord,
Hmm.
paragraph 22, I'm giving
Paragraph
22, my lord.
22. Hmm.
There you are also that on examination about finding as a learned single judge is a question of causing, my lord.
Hmm.
You find a learned single judge has not addressed himself to legal question raised before him by the appellant, that the criminal liability of the appellant under provision section 138 are attract only account of reason of check in discharge of debt or liability, but not account of issuance of security sake. Learned single judge is also not given cause and satisfactory exception. So on that point, it is a tribal issue. So matter was accordingly the cognizance order was set aside. Now, what has happened now? Thereafter, my lord, matter came before Justice M.R. Shah, my lord,
Hmm.
way back in 2022, my lord.
Hmm.
There, my lord, it was again this judgment was placed before the court, my lord,
Hmm.
and it was distinguished.
Hmm.
There, your lordship will find. There, they have this division bench of the Supreme Court, my lord. They have dealt with many other cases of
Which paragraph?
paragraph. It starts from paragraph 17, my lord.
Paragraph 17.
17 onwards. It's a long judgment, my lord.
Hmm.
Basically, there your lordship will find that they have paragraph 17. Your lordship may kindly come next page, my lord.
Hmm.
There they though the High Court has taken note of the decision of Sudhir Kumar
Just a
Bhalla,
minute, where? Achha, okay. Though the High Court has taken
the
note of.
the decision in Sudhir Kumar Bhalla, the earlier decision, told that checks issued as security cannot constitute an offence. Same is now it does not come to aid of respondent. There is no categorical declaration by the court in such case that checks issued as security cannot be presented to realization under all circumstances. Facts of each case are related to checks are issued and those are alterations made in the checks so and so. There were counter complaint filed by the government. Hence, this is cannot be treated as a precedent to answer the position in this case. Then subsequently, this court, my lord, in the said decision, my lord, you will also find number of case laws has been ultimately discussed, my lord.
Hmm.
Then your lordship, I'm not taking you trouble to your lordship. Finally, my lord, at paragraph 20, my lord. 21, my lord.
21.
A check issued as a security pursuant to financial transactions cannot be considered a worthless piece of paper under every circumstance. Security in its true sense, the sense of being safe and security given a loan for something as a place for payment. It is given the depositor place to make certain fulfillment on obligation to which parties to a transaction are bound. Even a transaction a loan is advanced and borrower agrees to repay in time frame. It should take as a security to secure such payment. If the loan amount is not repaid in any other form before the due date, if there is no other understanding or agreement between the parties to defer the payment, the check which issued as security would mature on presentation, and drawee a check would be entitled to present the same. On such presentation, the same so and so. So now, when a check is created as security towards a prepayment, so and so, or ensure that check which is related to security cannot be presented. When it also cannot be issued, cannot be presented prior to the loan of the installment maturing towards so and so. So actually, it depends on the nature of the transactions.
Uh-huh.
So now in this case, what has happened? The complainant has admitted that not against liability had issued the check. On the same day it was disbursed, the same sequence, but not against liability. Because our case that.
So according to you, check was issued as a security check which was admitted by the complainant. And check was deposited on which date?
After 5 months, before we get that earlier it was 6 months, minor. Before expiry of 6
So
months.
is there anything on your part that I have paid the amount on such and such date, therefore that security has
Yeah.
become invalid?
That we have given in our
I think
evidence.
that will be the given facts.
Yeah, because we have reduced evidence that we have paid the amount, but there was no acknowledged from the part of the complainant. That thing has come. There was no acknowledgement.
According to him, yes, I have not, I have deposited it was a security check. When it was failed, I have deposited a
Yes,
security.
but he has admitted one thing that it is not against the liability. That is important, madam.
Not against the
liability of
liability.
payment. Because discharge of liability only check can be issued by.
Okay, so according to your case, that he is not said that my due was not paid, therefore I have deposited the security check. Your case is that he said that it is check is represented not against the liability.
Liability.
So now what will to be interpreted that whether that sentence will mean that he has paid already the amount and I have deposited the security checks, or whether by virtue of that statement it will be concluded that in fact it was security checks not against liability, but when it was not paid, then only I have deposited. Now there are two courts. How did both the two courts dealt with in this issue?
They have never discussed. They were
Anything raised in as
we
this?
have raised, but now they never discussed.
Where have you raised and what is?
Process we have come by.
PW1 cause exam.
That there is matter of record.
Okay, PW1 cross exam.
Yes. That I am enclosed by that you know.
And closed. Okay. Page.
Assamese version page 24 your lordship.
Page 24.
On security হিসাবে my Assamese take check 1 lakh each other.
Where is the chief?
Please your lordship find at the page. Start from page
Okay, I'll read it translated only, no problem.
page 19 to 20. My lord.
What is your defense case?
Defense case is for what a check is concerned, it was not issued against liability security check.
But it is not your case that you have not taken the money.
Yes, but
Your case, your defense case is you have taken the money 2,70,000 and you have paid 1 lakh. This is your defense and these were the security checks. And what is the amount of this security checks?
2,70,000.
2,70,000.
So
Okay. And how this was dealt by?
lordship,
Where is your examination defense?
that I am not employed, my lord.
Where is it?
Cat will be out of the mouse.
That's why I'm asking.
Yes. And in the court of law, he files petitions. I'll pay in installment, 2,70,000. He defaults. He's arrested, put behind the bar. Then he's out. Then he takes a defense, my lord, that I have repaid it.
Now, where is that evidence of
DW1 is my lord.
DW1? Please, any copy with anybody?
Yes, I have got a copy.
Yes.
We did it for the court convenience, my lord. That is been recorded on 5/10/2011. মই আৰু গোপাল বহুত ভাল ফ্ৰেণ্ড হওঁ। মই তেওঁৰ পৰা 2,70,000 টকা লৈছিলো আৰু 3খন চেক মই তেওঁক চিকিউৰিটি হিচাপে দিছো। মই আৰু গোপাল ৰয়
বিজনেছ কৰি আছিলো। এক্সিবিট 1, 2, 3 মই দিয়া 3খন চেক হয় যি মই চিকিউৰিটি হিচাপে দিছিলো টকা 2,70,000 বাবে মই উক্ত চেকত কোনো ডেট দিয়া নাছিলো। দ্যাট ইজ হিজ ডিফেন্স। মই গোপাল ৰয় লাহে লাহে টকা দি আছিলো। দিছ আৰ দ্য এমাউণ্ট হি হেভ ষ্টেটেড টু হেভ ৰিটাৰ্ণ টু মি। মই গোপাল ৰয় টোটেল টকা 2,70,000 ঘূৰাই দিছো, কিন্তু মোৰ তাৰিখবোৰ মনত নাই। মোৰ গোপাল ৰয় টকা পে'মেণ্ট কৰা লিখা আছে। মই গোপাল ৰয় দিব লগা কোনো টকা বাকী নাই। মই গোপাল ৰয় টকা ঘূৰাই দিয়া হোৱাত তেওঁ কেছ উঠাই ল'ব কাৰণে ৰিকুৱেষ্ট কৰিছো, কিন্তু তেওঁ কেছ উঠাই লোৱা নাছিল। মই গোপাল ৰয় টকা পে'মেণ্ট কৰা কথা উল্লেখ কৰি বহু পিটিশ্যন ফাইল কৰিছো আৰু মোৰ আগৰ উকিলেও উক্ত কথা জানে। মোৰ আগৰ উকিলে শ্ৰী দিলীপ মই গোপাল ৰয় পে'মেণ্ট কৰা কথা জানে। ক্ৰছ মই 3খন চেক গোপাল ৰয় 2,70,000 কাৰণে দিছো চিকিউৰিটি হিচাপে। মই লিগেল নটিচ ৰিচিভ কৰা নাই, কিন্তু লিগেল নটিচৰ বিষয়ে গম পাওঁ। মই লিগেল নটিচৰ উল্লেখ কৰা মতে 15 দিনৰ ভিতৰত পে'মেণ্ট কৰা নাই। চ' দেৰ ৱাজ ন' ৰিপ্লাই টু দ্য লিগেল নটিচ। শ্ৰী দিলীপ দত্ত মোৰ কেছ প্ৰথম কণ্ডাক্ট কৰিছে। তেওঁ মোৰ কেছ চ' লেট চ' মোৰ মনত নাই। এক্সিবিট 112131 মোৰ চহী হয়। এক্সিবিটেড লিগেল নটিচ মই পাইছিলো। মই লিগেল নটিচৰ ৰিপ্লাই দিয়া নাই, কিন্তু গোপাল ৰয়ে লগ ধৰিছো। মই গোপাল ৰয় সকলো পে'মেণ্ট কেছ কৰিছো আৰু এটা ডিডি এমাউণ্ট 5,000 টকা পঠাইছো, কিন্তু গোপাল ৰয় উক্ত ডিডি একচেপ্ট কৰা নাই। 2005 চনৰ লৈকে মই কিমান টকা পে'মেণ্ট কৰিছো মোৰ মনত নাই। তেতিয়ালৈকে মই 7-8টা ইনষ্টলমেণ্ট পে'মেণ্ট কৰিছো গোপাল ৰয়, কিন্তু ডেট মনত নাই। এক্সিবিট 15 মই দিয়া পিটিশ্যন এই কোৰ্টত ফাইল কৰা 2/3/2005 উক্ত পিটিশ্যনত মই লিখা আছে যে গোপাল ৰয়ক পে'মেণ্ট কৰিবৰ কাৰণে 2,70,000 টকা ডিউ আছে। This has been accepted in the court of law, which I have exhibited. So the payment installment he has paid in installment is been nullified by his own admissions. উক্ত পিটিশ্যনত মই লিখিছো যে গোপাল ৰয়ক মই নেক্সট ডেটত ফিক্স কৰা 50,000 টকা দিম আৰু 10,000 কৰি বাকী টকা প্ৰত্যেক মাহে দিম। 15/1 মোৰ চহী। উক্ত এক্সিবিট 16/5 2,70,000 টকা দিবৰ কাৰণে মান্তি হলো আৰু তাৰ বাবদ মই নিজৰ মাটি বিক্ৰী কৰিছো, কিন্তু মাটি বিক্ৰী কৰাৰ টকা নোলোৱাৰ কাৰণে কোৰ্টৰ পৰা টাইম বিচাৰিলো। এক্সিবিট 16 মোৰ চহী। এক্সিবিট 17/22/2005 তাৰিখে গোপাল ৰয়ে ফাইল কৰা পিটিশ্যনৰ হৈ য'ত তেওঁ কৈছে যে মই 1 লাখ টকা দিয়া নাই আৰু সেইকাৰণে কোৰ্ট প্ৰচিড কৰিব লাগে। এক্সিবিট 17/1 মোৰ চহী। এই গোচৰত মই এবাৰ জেলত গলো। এক্সিবিট 26/9/2006 তাৰিখে মই দিয়া পিটিশ্যনত এই গোচৰত য'ত মই 20,000 টকা পে' কৰিব লিখিছো অক্টোবৰ লাষ্ট পাৰ্টত। এক্সিবিট 8 মোৰ চহী। মই পে'মেণ্ট কৰিছো। মই গোপাল ৰয়ক পে'মেণ্ট কৰা বাবদ মোৰ তাত কোনো মানি ৰিচিট নাই, মোক দিয়া নাই। মই কোৰ্টত আগ পে'মেণ্ট কৰিছো, কোনোবা ধৰ আছিল। মই তেওঁৰ লগত 10,000 আৰু 20,000 টকা উক্ত ছাৰক ওচৰত কৰিছো। উক্ত কথা কেছ ৰেকৰ্ডত ৰিফ্লেক্ট হৈছে নে নাই মই ক'ব নোৱাৰো। উক্ত পে'মেণ্ট মই 2007ত কৰিছো। সত্য নহয় যে মই ধৰ আগত কোনো পে'মেণ্ট কৰা নাই। 2007ত যিহেতু 2007ত কোনো ধৰ ছাৰে এজ মেজিষ্ট্ৰেট নাছিল, মোৰ মনত নাই 2006ত হ'ব পাৰে, 2007 হ'ব পাৰে। সত্য নহয় যে মই সময় লোৱা স্বাৰ্থে পে'মেণ্ট কৰা নাই। এই গোচৰত মোৰ গোপাল ৰয়ৰ লগত পাৰ্টনাৰশ্বিপ আছিল, কিন্তু মই কোৰ্টত কোনো পাৰ্টনাৰশ্বিপ ডিড দাখিল কৰা নাই। সত্য নহয় যে মই 5 পইচা পে'মেণ্ট কৰা নাই এই গোচৰত। সত্য নহয় যে মই পে'মেণ্ট কৰাৰ কথা ওথ লৈ মিছাকে কৈছো। মোৰ কোনো ডকুমেণ্টাৰী প্ৰুফ নাই মই টকা দিয়া বুলি গোপাল ৰয়। মোৰ নিজৰ মাটি নাই। এক্সিবিট 16 লিখা আছে যে মই মোৰ মাটি বিক্ৰী কৰিছো 3খন চেক পেমেন্ট কৰিবৰ কাৰণে উক্ত কথা মোৰ এডভোকেটে লিখিছে মই পঢ়ি চোৱা নাই মই চহী কৰিছো এক্সিবিট 16ত উল্লেখ কৰা বিক্ৰী কৰা মাটি মোৰ মাদাৰ ইন লৰ বিক্ৰী কৰিছে তেওঁৰ মাটি লৈ মই মোৰ কোনো মাটি বিক্ৰী কৰা নাই এক্সিবিট 16ত লিখা কথা যে মই মোৰ মাটি বিক্ৰী কৰিছো সত্য নহয় this is the quality of evidence and they have taken a plea my lord from the suggestion it appears that check was given as security and a date was not there and they have not disputed sending it to the handwriting expert also and their case solely like my case is as simple as this yes check has been given for a period of 5 months and there was date and complete check. It was as a security to me till that time. The moment it has been, got it validity, from the date it gets validity for 6 months at that time. Within that time, with instruction from him, I presented this. If this honorable court goes through the complaint petition itself, your lordship would be pleased to appreciate that. On instruction of the accused person, I deposited the check.
Where is the complaint petition?
Yes. Annexure 1, paragraph 4 minus. The complaint states on 26/7/2000 as to the instruction of the accused above named, the complainant deposit the aforesaid 3 checks before his banker. So it was a security check. It will not get, my lord, validated before the date. What is the date on which the money has been taken is also been reflected. That is 19/2/2004. The accused above named took a loan of 2,70,000. 19/2/2004, so and so, so and so. And for a period of 5 months. So 19/3, 19/4, 19/5, 19/6, 19/7 is the date. And 26/7, when the check got validated, then I, with the instruction, presented this and it has got dishonored. And these are nothing but afterthought because as per the NIA, cause of action doesn't arise till 15 days. From dishonor, if my lord, this notice is not been issued. Notice has to be issued in 15 days. And he gets a opportunity to reply. There is no reply. And he gets
No, your whole case is that yes, check was issued
Yes,
on the same date, 18/2/2004.
yes, as security.
As security.
Yes, and
But
yes,
for 5 months, when
Yes.
5 months is over, I have
yes, it
deposited.
gets this. And this Vala case helps me, my lord. His judgment, my lord, has been referred to it. Is on the facts of the case, my lord. This is my case. As
Okay.
simple as that.
Will dictate at 2.
Yes, deeply on that.
How many matters are there? Now tell us who are willing and ready to do cases. Control. Both are same, na? That Mahajan's case and your case were similar.
Already they have been sent.
No, that we understand, but we want your assistance. Just so we fix this matter, it will be pass a common order 11:30, na? Hard in part karge. Yes, who are the others councils to argue?
For my case is your my case, my lord, that you'll also kindly see that judgment, my lord, that
Yes, that we'll see. That's why we'll see in the recess and come back and dictate this order
yes,
at 2.
No, it's
Yes,
okay.
what are the cases? Hack কৰিলে মিলা পিছতো হ'ব। Yes, Madam Sharma.
Lordship, death of a person due to accident. 79 and 304A, Lordship.
What are the evidence as regards negligence and rash and negligence?
Lordship, it's
Any eyewitness specifically says?
exactly one person said that the car.
No,
Yes.
don't. Somebody may say it was in high speed, it was in this speed, but whether any attributable that it was done, this, nothing.
There is no evidence that actually the car was in a high speed because some the 330 statement is that he had not hit, only he had lifted the person to the hospital. That is his stand. The accused person's stand is that.
And what is the eyewitness? Who are the
My lord,
eyewitnesses?
eyewitness PW3, my lord.
Three.
It will be clear from the.
Where do you get it?
I flag my lord.
Check mark in
LCR.
LCR.
LCR, man. LCR.
We'll do or dictate all this order at 2. Just I want to look into this.
LCR.
Lordship, I have a talk with A. Ahmed that 354 prior to 2013 there is an OR. So
Okay. Okay. Okay.
substituted.
Huh.
It was
Okay.
substituted.
Okay. Then it's fine. Then we'll say that nothing. We'll pass that order all today itself. That order, item number?
Item number 7, Mahajan and Mahajan may be called because he was a
Oh, Amicus. He was
Call Mr. and Mahajan at 2. Huh? We'll do that. We see if you can finish, we'll just close it in that point. My idea was that, so if that is so, we cannot,
Yes.
if that is or at that point of time, we'll quote that provision.
judgment is of 2013, but incident is of
Incident took place because
2007.
there's 7. That right will be there. Which is substantive law. Yes, 7, not now, at 2. This is just I want to see PW1.
PW3, man.
PW3.
3, 4 eyewitness.
I just want to see eyewitnesses.
Fine. First 3.
How many years convicted?
Convicted, this is, there is also or lordship and
Initially, it was 4 months, my lord.
Then
Thereafter, it was
it modified to 300 and fine. 3 months and fine.
PW1, na?
PW3, my lord.
PW3. As
Eyewitness.
PW3. Then 4. Okay. We'll come back at 2.
Well, one important thing is that, my lord, although he has total denial in 313, my lord, but from the statement of PW5, who is the owner of the vehicle, and PW6 also, my lord, he has informed the owner that one accident took place with this vehicle, my lord.
3 months, na?
3 months. Here PW3, but he in her evidence stated that hearing a loud sound came out from house. So
PW.
whether how much
Yes, seen or not.
yes, and
That will come back at 2.
yes, Lord. And one thing is that from postmortem report, although he was knocked down, there was possibly no injury. He should have get some injury on his back.
Because it's a
Yeah,
backside knockdown.
backside. But from
What is the reason of death?
death is
hemorrhage?
only one hemorrhage in temple
Coma.
area. That is.
Okay, we'll consider at 2.
Okay.
Which we can dispose of, we'll take at 2. And what are the other matters? Yes, alarm was there. We'll take up at 2. Yes. At 2?
The senior
Huh? Who is your senior?
time may be taken
Who is your senior?
as the
S? Item number?
18.
Okay, forget about S das. Now what about J Dalam and M Pandit?
Possible for the time being.
At two, we'll take at two. Two means before that we'll pass an order in both of, I will take both of your cases. We'll then dictate and thereafter we'll take Mr. NI case. We'll finish this three, then we'll come to this criminal. If I'll into diversion, that we have fixed in at two. All likelihood you are dismissing his petition. So we'll get this order by next week, uploaded. We'll just let us do other 2-3 things. Yes. 7 was that method, no? Hard. আগৰ কথাখিনি লিখিছিলো কবাক that none appears so and so so and so. Who took this dictation first half? Let I'll correct that or keep that order. Okay, so and so so and so. Accordingly, this court requested Mr. N. Mahajan to represent the accused number 2. Then earlier things I have already written, na FIR and all. Huh? I wish why should we dictate twice? Already I have dictated. But Mahajan, you go to that jurisdiction point. You'll have to go deep. Because what is jurisdiction? How it is confirmed? What do you mean by, don't go by criminal cases only. Go to other writ petitions and all constitutional debates are already there. You will get an highlight from that judgment. How it is dealt jurisdiction. So if it is go to the root of the matter, it will be, first part will be there. Different. Accordingly, this court. Okay. Positive. Though it is a ground the fundamental ground raised in this revision is that the decision of the learned court below in sentencing / imposing punishment under section 354 IPC is without authority of law and without jurisdiction, inasmuch as such provision prescribes and sentence not less than 1 year. However, the learned trial court has sentenced the respondent number 2 to to imposing a fine of rupees 200 only. Full stop. MS B. Sharma, learned amicus. Learned amicus submits that the offense was admittedly committed, or offense was admittedly committed on 19th of May 2007, isn't it? 19th of May 2007. And at the relevant point of time, the punishment, the prescribed punishment for commission and offense under section 354 was
An imprisonment of 2 years
Or with fine.
or fine.
imprisonment of 2 years.
With imprisonment of either discretion.
Prescription of punishment was, just tell me,
This may extend to 2 years
for
or with fine.
punishment which may extend to 2 years or
With
fine,
Or with both.
or with fine, or with both. And therefore, it cannot be said that the learned court was without jurisdiction to impose a sentence of payment of fine only. Full stop. Mr. Mahajan, learned counsel, Mr. Mahajan also submits that it cannot be said that the learned trial court has committed any error of law warranting exercise of this court's power under section 482 CRPC. It is his contention that punishment being a substantive law, punishment prescribed under IPC being a substantive law, the amendment of the same cannot be inflicted, amended punishment cannot be inflicted upon an accused on the date of conviction and sentence, and the conviction and sentence must relate back to the provision of substantive law which was available at the time of the commission. Full stop. This court is also in total agreement with the aforesaid arguments of the parties, in as much as until and unless a law is expressly declared or by implication it is made to be retrospective, there is always a presumption that law enacted is prospective. When the offense was committed, the prescription of punishment under section 354 was either maximum 2 years of sentence or fine or both. Such prescription was amended by
Amendment of.
Amendment Act of
13 of 2013.
2013, whereby the punishment was prescribed. Punishment for commission of offense under section 354 was prescribed to be
Not less than 1 year,
not less than 1 year,
but which may extend to 5 years.
and which may extend to 5 years,
And also
and
shall be liable to fine.
and also fine. Thus, earlier, that is pre-amended provision prescribed either of 3 situations, either punishment which may extend maximum to
2 years.
2 years, or
Fine.
payment of or imposition of fine. However, by view of the amendment, a minimum punishment is been prescribed and a fine. imposition of fine. Full stop. In the considered opinion of this court, such prescription of punishment post amendment cannot be made applicable in the given case of the present case when such amendment admittedly is prospective and with effect from 3/2/2013 and the offense was committed on 19th of May 2007. Full stop. That being the position, this court do not find any infirmity or error of law in the impugned order. Accordingly, same stands closed. This court, while parting with the record, puts on record the able assistance rendered by MSB Sharma and Mr. Mahajan. Full stop. Registry to the needful for so and so for payment to MSB Sharma, not to you, because you are for the accused. Okay. What is the 12? Okay. This is also your case, item 12. 12 is what is 12? That Mr. We'll pass this order, dispose of. That Mr. We'll pass this order. This. Keep this, huh? Etu ki asle? Etu ya leke ahibo, tar pisot moi sign. Acha 14. What was that 14?
Rash and negligent driving.
Rash and negligent. Mr. Sharma, these cases, accidents, so many years suffered, will not like to send him to jail at this stage, and that too in the backdrop of the evidence. Hard.
It's also very difficult to prove rash and negligence.
Difficult to prove, but no, you can prove. There are many cases where it has been proved. At least description, how it has come, what is this. In the last case, it was National Highway 87. He was in speed. Will it mean that it's a rash and negligence? A vehicle may driven, necessarily driven in a high speed in a national highway.
He had not escaped lordship. He stayed and take him to the hospital. That is
Next to the hospital, he used brakes, what not? We'll allow this petition. Hard. Where is not? Okay, already you have declared or it will be, rest will be similar, evidence are also same. Yesterday, today I have signed an order, Mr. NNB Chaudhuri, dispose of. But write it down, she is appeared as an amicus. So amicus part will be added.
obliged.
All this you will get in the next week. Others are, I will finish up all pendings today. That's all. Appeal. Yes, Alam.
There are 4 connected appeals.
What is the judgment?
Sentence, Lordship, is 304 part 2.
30 part 2.
3 years.
3 years.
There were 7 accused persons were charged sheeted. Out of them, 2 were found juvenile and they were sent to juvenile board. The prime accused, as per the allegation and evidence, Rajiv Hussain, he was found juvenile and he was sent to the juvenile board. I'm not aware what was the consequences in the whether he was found guilty or not. And subsequently, after trial, one Hemant, accused number 7, he took the plea. He was also sent to the, ultimately 5 persons they have faced and they have been sentenced for.
Who died?
No, nobody died.
Nobody died.
Nobody died, but item number 15, Mr. D. Lal was holding the brief and I have heard that he is no more.
He is no more.
No more.
We'll have appoint.
Nobody is representing him. In
Okay.
item 18 also nobody is representing.
Who is item 18?
Item 18.
Who is your senior?
Soilen Das. S. Das.
Soilen Das.
Soilen Das means our president.
President.
Where is he? That cannot be a ground. He is not here. Why he is not here? You'll have to say he's in hospital.
He is so suffering.
Is he? What happened to him? You do it. You are here. Okay, and Mr. Alam, who is the other in the other case?
I'm representing two persons, 17,
You are
16 and
representing
17.
17 and
16 and 17.
16 and 17.
18, Sulendas is there.
Okay, Solendas is still there. We
Uh,
will record his
and
presence.
15, Dr. Lal was there, but
Okay,
Nobody
you
has-
take it out. This batch of appeal is filed assailing. Take it out, Adiba, huh? Assailing judgment and order dated 2/4/2014 passed by the learned additional session judge number 1 Kamrup at Guwahati in sessions case number 278 within bracket K/2001. Under section 304 part 2. I thought it was 304A. 304 part 2
to the age of 34.
/34. The learned counsel R.D. Lal representing the appellants in criminal appeal number 2012/2014 had in the meantime expired and none appears for the aforesaid appellant. In view of the aforesaid, this court has requested, yes, Mr. Mahajan, we are giving you additional burden. This court has requested Mr. N. Mahajan, learned counsel, to represent the accused in to argue on behalf of the appellants in criminal appeal /212/2014. Full stop. Accordingly, registries to give necessary papers connected with the appeal to Mr. Mahajan and list this matter for hearing reflecting name of Mr. Mahajan in the cause list on
2 weeks is asking for 2 weeks.
2 weeks. Definitely we will have to go. Ultimately, appeal, it's not like revision. January. Tenth of January. Where is the FIR? FIR is somewhere.
Second reason. All were school, college going students. They were collecting money for going to picnic. Somehow they had an altercation, and the spur of moment, the incident has taken place.
Any eyewitness?
Yes.
What is
PW2.
their version?
His version is contradicting with PW4. There are 2 eyewitnesses,
Ah.
projected eyewitnesses.
Mm.
PW4 is not supporting PW2.
Two.
His version is totally different. There are 3 incidents taken place. One at 11 p.m., thereafter 5:30, then thereafter 7:30.
Okay.
People.
And you are for? Informant?
Informant was declared hostile in the trial.
Okay. How informant is related?
Uncle.
Uncle.